All right, let's go on. We're going into DC 2320444 Simmons Bank versus Kimberly Jones. Council, make your appearances.
Thank you, William Wells, on behalf of the plaintiff, Your Honor.
Tommy Skaggs on behalf of the defendant, Your Honor.
All right, let's proceed.
Thank you, Judge. The plaintiff filed a motion for summary judgment. There was an amended motion filed on February 12th, 2024, and the plaintiff, Simmons Bank, made a loan to the defendant, Kimberly Jones. The loan was May 19 of 22 for a principal amount of $17,112.00. The summary judgment motion and the declaration indicate that the defendant defaulted on the loan, and there's a present amount due of $18,256.73 as of December 15th of 2023, and that's the basic relief sought. The motion for summary judgment order that was submitted to the court request the principal amount of, or the amount of $18,256.73, which is the principal with interest at 11% per annum based on the note. And they're also seeking, for the order, interest, post-judgment interest, and cost. The suit was filed to seek relief on a sworn account, a promissory note, and a breach of contract. There is a declaration attached to the motion for summary judgment regarding the note and the default. The defendant filed a response with multiple allegations why the summary judgment should not be granted, and the plaintiff filed a reply to that, which the court should have. And I wait until the defendant makes their motion to address their argument.
Yeah, so they filed a motion to continue. Is that correct?
Yes, Your Honor.
All right, go ahead.
Yes. Initial disclosures were not due until March 1st of this year, and it's premature. We need more time for discovery to determine if there are offsets that we need and the payments made.
Okay, response?
Judge, there's not a time restriction on a traditional motion for summary judgment, and if the defendant's contending they haven't had adequate time for discovery, they must file an affidavit explaining the need for further discovery and specifically what they need. And in this case, it's a suit on a note, and the defendant hasn't requested through discovery any documents that they maintain should preclude the court from moving forward on the summary judgment at this time.
Your Honor, our position is that the summary judgment motion was premature because initial disclosures were not due until March 1st, and it is now March 4th, and it's no wonder we haven't filed for discovery yet.
I think his problem with this is that you didn't provide an affidavit. Is that correct?
I'm not, Your Honor, that would be in a record, whether there is or isn't.
Your Honor, the response that was filed with the court includes the verbiage: when a party contends that it has not had adequate opportunity for discovery prior to a summary judgment hearing, it must either file an affidavit explaining the need for further discovery or a verified motion for continuance. And the affidavit must describe the evidence sought, explain its materiality, and set forth facts showing due diligence used to obtain the evidence. And that's the plaintiff's response to the defendant's urging to delay this.
And it seems like reading the affidavit, it doesn't really do that. Is that correct?
Are you asking me, Your Honor?
I'm asking opposing counsel.
Okay.
I'm not aware of the affidavit, Your Honor. I'm sorry, I cannot provide information on that.
The affidavit that your office filed?
Correct. I cannot provide information on that. I didn't find it in the things that I have.
Okay, so there is no affidavit. I think that's the bottom line.
Okay.
Correct?
Okay.
So, are you appearance counsel? Is that the deal?
Correct, Your Honor.
Okay. I think he's technically correct. You just may want to mention to whoever's office you're covering for that they need to make sure that they include an affidavit that details in the future. So I'm going to go ahead and grant the summary judgment.
We do have some disputes about the summary judgment, Your Honor.
Go ahead.
Yes. Where is it? Our first dispute as to whether there's a genuine issue of material fact comes within plaintiff's amended motion for summary judgment. And on page 3 in paragraph 7, I think it's A, B, and C. In sub paragraph A, on or about December 8th, defendant executed a credit agreement and disclosure contract. So then it goes into B, they refused to pay on August 8th. How can you have a request to pay before the contract is entered? That's what this shows. And the same thing is on C, the notice of default was mailed on October 30th. Well, how can you mail a notice of default before the contract? So there is an issue of material fact.
Response?
Yes, Your Honor. When I read the motion, I saw that same thing. I would assume it's a typo on the paragraph that he referred to where it has the December date. The December date was when it was calculated with the current amount due with the interest, and the attachments, which are the summary judgment evidence with the note, clearly shows that the note was executed by a defendant on May 19th of 2022. So there's a typo, I would assume, because it's got the wrong date, and that date was the same date as when they calculated the current interest and principal that's owed on the note of $18,256.73. But the summary judgment evidence are the attachments, which include the note, and that clearly shows the date the note was executed. And I think the typo in the motion, I don't think it's relevant.
I mean, but doesn't that kind of, if it is, we don't know for sure it is a typo, correct?
Well, correct. Your Honor, I think it's safe to say it is a typo because the notes that's attached clearly shows that the note was executed on May 19th of 2022. And it's, whoever prepared this motion took the same date that the principal and interest was calculated and plugged it in there. But it's not consistent with the evidence that's before the court as far as the motion for summary judgment evidence. And I think I saw the same thing when I saw it. I thought, that's not right because it doesn't make sense. But I don't think that's material to the court's consideration of the summary judgment evidence, not what's in the motion. But if the court thinks,
Your Honor, it speaks for itself, and there's no mention of reference to an affidavit in here that should support that date or any other date.
Yeah, I think it's, Mr. Wells will give you two options. One, you can reset this and fix it. And that'll give Mr. Skaggs an opportunity to file maybe a corrected affidavit on his motion for continuance, or I can just deny it today.
I'll take the first option, Your Honor.
All right. We'll go ahead and reset this. Let me just double check one thing. Just to see if we have a trial setting on this one. Yep, we have an October 22nd trial setting, so you have plenty of time. So just get that fixed and we'll take care of it. You guys have a great rest of your day.
Thank you, Your Honor.
Thank
That would be
you.
excused,
You may.
Judge. Thank you.
Thank you.